And thirdly, it has to be sufficiently detailed to cover the cause of the accusation in both fact and law. It is not a requirement at this stage to furnish evidence, because this is the preliminary stage. There is a knock-on requirement at a later stage that the contents of an indictment have to be sufficiently detailed and contain evidence. But at this preliminary stage that we're looking at, it just has to be sufficiently detailed, citing the law and the facts upon which the authorities are relying on. Again, this is set out in more detail in the paper, and I'm just summarising the points. The next area is that the defence have to be provided with adequate time and facilities. Now, we need to understand what adequate time and facilities actually means. And it has to be assessed on a case-by-case basis, taking into account the complexity of the case which we face. The authorities are required to provide the defence with the time and facilities in order to prepare their case. In circumstances where a limited time period of, for example, 3 weeks to prepare a case, in a complex case, is unlikely to meet the requirement of time and facilities. The government has responded recently that adequate time and facilities will be provided to the defence. It's unclear what they mean by that, and time will tell to what extent the rules and the Act will be amended. But certainly a limited period of time to prepare for trial in what is effectively an international criminal charge will have to be a lengthy period of time. Having worked on a number of war crimes cases, 12 months is not considered to be a lengthy period of time in which to prepare for trial, from notification of the charges and the material that the prosecution is relying on. This right has to be taken in connection with the general right to a fair trial, because it is this, taken with the principle of equality of arms and the obligation of disclosure, that contributes to making a trial fair. The next point I'd like to consider is the right to summon and examine witnesses under the same conditions as the prosecution. This is an extremely important right in these types of cases. Now, I'm not going to go into any great detail, because this includes the concept of the use of protected and anonymous witnesses. This is a serious problem in these types of cases, because the vast majority of live witnesses will tend to be insider witnesses. It's very difficult to challenge their statements without knowing their identity. However, the state is under an obligation to protect witnesses who give evidence at trial, and so there has to be a counterbalancing act. However, there is a general principle that an international body such as the Human Rights Committee, interpreting the International Covenant, does not set rules of evidence. It's a matter of looking at whether the proceedings taken as a whole were fair, and looking at how the prosecution's case has been presented and how the defence has been able to challenge that case is a very important consideration. And what we must remember, that the rule is that the prosecution, or rather the court, cannot base a conviction on evidence that is either solely or to a decisive extent not been challenged by the defence. By this we mean it cannot rely exclusively on hearsay evidence. It can't rely exclusively on anonymous witnesses. There has to be supporting evidence. This is going to be a huge challenge to the prosecution in these war crimes cases, because we're talking 39, 40 years ago. There's going to be very little live witness testimony. The majority of the evidence is going to be hearsay. Now, hearsay in international trials is not prohibited, unfortunately. But there has to be very strict rules on how it can be used. That's what we want to see in how the tribunal conducts itself and how the Act and rules will have to be amended. It is insufficient to say there shall be no formal rules of evidence. There must be rules of evidence, and there must be limits on the kind of evidence that can be used. The final point that I'd like to make in relation to minimum standards for defence, or minimum rights of the defence, is the right to effective legal representation. I'd like to make it clear that we are talking about effective and practical representation. We are not talking about a lawyer who has been merely nominated to act for a defendant, and the court is under a duty, whether it likes it or not, to ensure that representation is effective and adequate. There may be the question asked whether the counsel in particular has sufficient knowledge of international criminal law. Because if a counsel does not have sufficient knowledge of international criminal law, the question may be raised as to whether he can provide an effective defence to his client. If the rules are such that the defence are prevented from carrying out an effective defence, then counsel must ask himself the question whether he should remain. His professional obligations as an officer of the court and his professional duties to his client are such that he must assess whether he can provide effective representation to his client. And that's a very important rule to remember. International criminal law is a relatively new subject. Lawyers have only been setting themselves out as specialists for probably about the last 15 years. It was previously within the remit of public lawyers as opposed to criminal lawyers. But it requires a combination of both. It requires a knowledge of the laws and customs of war. It requires in-depth knowledge of customary international law, of human rights law, of trial advocacy, of working in a common law system and working in a civil law system. These are the skills that international lawyers have perfected through working with the international tribunals. And if you are intending to practice in this area, I would suggest that you engage yourselves now in coming to terms with acquiring those skills. That shouldn't be underscored. It is arguable that it is also a duty of this government to ensure that their judges, investigators and prosecutors also have those skills. Having met the judges, they do not have those skills at present. And it is arguable that they should be given those skills now. Now, I appreciate it's taken rather a long time for me to get on to what is effectively the main purpose of this, and that is, actually my time is up. What I had hoped to speak about also is adverse media reporting and the presumption of innocence. If I can be granted an additional 5 or 10 minutes, I'll run through it as quickly as I possibly can. But you have the paper in front of you, and I'm happy to answer any questions. The point is this: the media contributes to ensuring that trials are fair. They are the watchdogs of fairness. They have to carry out this task responsibly. But the important rule that you have to remember is that a journalist cannot breach the presumption of innocence. The state can. An agent of the state can. A prosecutor can. A judge can. A minister can. A journalist can't. But a journalist can create an atmosphere of hostility that removes or limits the right to a fair trial. And that's an important distinction to make. I won't go through the requirements for presumption of innocence because I'm sure that the majority of you are quite familiar with that. But I wanted to make the distinction. It is a journalist's obligation to report trials fairly. Now, earlier today, I spoke to a journalist who has reported on these trials, and I asked the question, how many journalists in this country are adequately prepared to report on war crimes trials? Now, my view so far is very few, if any, have any experience in reporting on these trials. These trials carry with them a special responsibility. They have to be reported independently, without opinion, reporting on the facts alone, without fear of criticising the court.